She thought she had sealed everything with a single signature. She thought the will would erase me. She did not plan on the bank contract, the audio file, or a judge who reads every line. Narrator's name, Mara Ellison. My channel is called After Her Lies. The video you clicked promised a reversal in probate, and that is exactly what happened. I am 34. I live in Austin, Texas. My father, Daniel Ellison, died on June 3, 2022. His widow, my stepmother, believed she would control every dollar and every decision. The number you saw in the thumbnail, 180,000, is accurate. The figure came from a single account at Lone Star Bank ending in 6172. You will hear about a will signed on May 14, 2018, a durable power of attorney notarized on February 10, 2021, and a beneficiary designation that never made it into the family conversation because it did not serve her story. This is the episode where I sit at a mahogany table, hear my name omitted, and then decide to fight with the calm that the internet says I lack, but that grief taught me to carry. Act 1 begins at the funeral reception in Travis Heights. Aunts, cousins, the church choir, and 3 people from Dad's old HVAC shop crowded the living room. My stepmother, Linda, had arranged framed photos in a tight row. None included me beyond middle school. She was efficient about memory. I was the adult daughter from his first marriage, the one who moved to Austin for journalism school and stayed, the one who pushed back when Linda started answering Dad's texts. Dad and I were not estranged. We spoke every Sunday at 6. He liked my channel even when he did not like the title. He called it sharp. He said it made him proud that I did not let people manipulate the record. 2 days after the funeral, we sat in a conference room at Carlson Wirth, the probate firm Linda had chosen. The decor was heavy wood and framed degrees. The associate, a man the age of my high school boyfriend, slid a stapled will across the table. It was dated May 14, 2018. It left the house at 1120 South Larkspur to Linda, outright, and the residuary estate to her as well. There was a pour-over clause into a revocable trust that named Linda as trustee. There was a no-contest provision. There was a schedule of personal property that covered the Ford F-150, the set of craftsman tools, and a guitar I used to fall asleep to when I was 7. There was also a codicil from September 2020, notarized, that confirmed the same distribution. The figure of 180,000 did not appear in the will. Money rarely appears in wills by account. The omission was not evidence. It was a common drafting style. But Linda presented it like a verdict. She kept her public voice low and even. She said the will closed the conversation. She said I could pick one keepsake with sentimental value. She said the truck would be sold to cover estate expenses and that I could speak at the memorial service if I agreed to the plan. Otherwise, she would prefer to keep the program consistent. I asked about the bank accounts. She said those were part of the estate as the will stated, and that she would manage them as the executor. She used the right word. She had a letter of administration in process. The associate lawyer nodded. He said probate in Travis County could take 6 to 8 months. He said real property transfer would be straightforward. He slid a form authorizing him to act. He said it would save us trouble. I had a different memory. On November 28, 2021, 2 days after Thanksgiving, Dad and I sat in his truck in a Whataburger lot on Riverside. He told me he had made the savings account payable on death to me because he wanted me to finish what I had started, whether that meant a down payment or the documentary series I had been outlining. He said Linda would have the house and the shop equipment, and that seemed fair. He said he had already mailed the beneficiary form back to Lone Star Bank. He said he had called the bank manager to make sure it was active. I did what I do on my channel. I asked permission to record. He said yes. I tapped the red button on voice memos and labeled the file Dad Bank Pod. We ordered a number 1 with cheese and onion rings. He handed me a birthday card with a check for $400 and a note in block letters, as always. At Carlson Wirth, I did not play the audio. I did not argue. I asked for copies. I asked for the estate inventory when they had it. I asked for the original will location. I signed a receipt that I had reviewed. I went home to my one-bedroom on South First and did what I do best. I read. Texas Estates Code is not a thriller, but the rules are specific. A payable on death designation is a non-probate transfer. It bypasses the will. The durable power of attorney Linda had used before Dad died ceased at death. That matters. The account ending in 6172 had been opened in 2012. I had the statements because Dad mailed me one after the Whataburger talk so I would see the exact dollars. The last statement he had mailed showed a balance of $179,423. 13 as of November 30th, 2021. Interest would tip it over 180 by June. The pressure began in small and public ways. At the memorial service at St. David's, Linda chose a slideshow where my photo from high school theater class appeared for 2 seconds between a Cancun beach shot and the shop's Christmas party. Her niece introduced me to donors as the blogger. I corrected it twice and then stopped. After the service, Linda posted a Facebook status thanking everyone who loved Dan. She tagged 21 people and not me. My cousin sent me a screenshot. The caption read, "A life well put in order." That line stuck in my throat. Order is a choice. Order can be a weapon. When I called Lone Star Bank to ask about the beneficiary designation, the representative said he could not discuss specifics without the executor. When I mentioned the recording of my father and the date he had said he mailed the form, the representative said I should bring a death certificate and a copy of the will and meet with the branch manager, who would advise. I did not have letters testamentary. I was not the executor. I could not force a conversation. I could, however, request the branch camera logs for the day Dad and I visited, to show presence and timing, and I could pull the exact language of the bank's payable on death agreement by opening a personal account and asking for the standard terms. I did both. The POD language contained a survivorship requirement, 120 hours, and a priority order of beneficiaries. It also had a clause that said the bank would treat a completed and accepted designation as controlling, regardless of later conflicting wills, except in the case of a court order. I hit my first obstacle when Carlson Worth filed the application to probate the will and asked the court to appoint Linda as independent executor without bond. The court scheduled a short prove-up, standard. The second obstacle arrived as a letter from Linda's lawyer to me, stating that any attempt to interfere with estate administration would be treated as a contest. The letter quoted the no contest clause. It warned that challenging the will could forfeit any bequests I might receive. I had no bequest under the will. The letter was designed to chill me. It did not. It sharpened me. A no contest clause does not reach non-probate transfers. The bank account was not under the will if the POD existed. My leverage would not be a loud accusation of undue influence. It would be a contract that did not care about anyone's feelings. I created a timeline on my kitchen table with blue painter's tape. June 3, 2022, date of death. September 2020, codicil. February 10, 2021, power of attorney. November 28, 2021, Whataburger recording and beneficiary form mailing. December 3, 2021, Dad called the bank manager. How did I know the last line? He left me a voicemail by accident. He thought he had called Linda. He said he had sent the form certified mail because of the holidays. He said he wanted to make sure his daughter would be okay. The voicemail sat with the other saved ones I had never deleted. It was 37 seconds long. It included the manager's first name, Alan, and the phrase, "pay on death." The file metadata showed the timestamp 9:42 a.m. and the originating number, Dad's. I tracked down Alan. I went to the branch at Congress and Old Torf with the death certificate. I told the teller I needed to speak to the manager about closing an account and beneficiary designations in general. I did not mention Dad. When Alan stepped out, he froze for a second. He recognized me from visits with Dad. I said I needed guidance. I pulled out the bank's standard POD agreement and asked him to walk me through enforcement when the executor disputes it. He said the bank follows its records. If a designation is on file, they pay the named beneficiary after verifying the death certificate and identity. If an executor objects, the bank can interplead the funds into court. I asked if he remembered receiving a certified mail packet from my father in late November 2021. He squinted. He said he would need to check the mail log. I nodded. I said I would not ask him to release anything that day. I handed him a letter with the case caption, "In the estate of Daniel Ellison, cause no." 2022 PR 1642, Travis County, along with a preservation request for all account records, mail logs, and internal communications regarding the account ending 6172 from November 1st, 2021 through August 31st, 2022. I told him a subpoena would follow. I had not yet retained a lawyer. The letter was a template I adapted from a friend's civil practice. It still speaks in the language institutions respect. When I left the branch, Linda texted me. She said she had learned I was snooping and that Dad would be embarrassed. She said the house was going to be more expensive than expected and that I should try to be supportive instead of adversarial. She said, "Whatever is in that little blog, do not slander me." The phrase was hers. The pattern was familiar. Control through shame. Control through implying that grief is a form of disloyalty if it does not obey. I hired a probate attorney named Karen Pierce. Gray braid, quick eyes, direct. She charges $450 an hour. We talked for 1 hour, 8 minutes. She said 2 things that mattered. A payable on death account is outside the estate, and a power of attorney ends at death. If Linda used the POA to move money right before or right after death, we could ask the court to surcharge her and order repayment. Karen filed an appearance for me as an interested person. She filed a motion to compel the bank to produce the beneficiary designation if it existed. She filed a motion to require Linda to post a bond because of a conflict of interest regarding the account. She also served Alan with a subpoena duces tecum. The hearing landed on August 22, 2022. Between filing and hearing, Linda escalated. She called my grandmother and told her I was trying to take the roof over her head. She called my mother and called me unstable. She posted a photo of a cardboard box labeled Dan's stuff and said how difficult it was to sort through a lifetime while being attacked. She blocked me after I texted her that we could handle this in court. Friends sent screenshots. Viewers sent prayers. I did not reply to anyone. I focused on documents. Karen received bank records that showed 3 transactions on June 4th, the day after Dad died, processed June 6th. The transactions totaled $6,412.58. Linda had used Dad's debit card to pay the funeral home deposit and 2 Home Depot charges. I did not begrudge funeral expenses. The card use mattered as a legal point. The bank also produced a scan of a POD designation, received December 2nd, 2021, signed by Daniel Ellison, witnessed by a teller named Rosa, naming me as the sole beneficiary. The bank had accepted it. The image included a barcode and the words, "Accepted per policy." 12. 2. Alan included an email to legal dated June 7, 2022, noting the conflict between the executor and the beneficiary and asking whether to hold or interplead. Legal replied, "Hold pending court direction." I stared at the scan for a long time. The bank had what we needed. The policy had what we needed. The will could not erase it. I felt a second obstacle when Karen told me about the risk of the no contest clause if Linda argued that my motions were a will contest in disguise. Karen said we needed to be precise. We were not challenging the will. We were asking the court to acknowledge that non-probate transfers are not part of the probate estate. We would bring the statute. We would play the audio only if necessary. We would keep the fight about documents. The judge assigned to our case, Judge Naranjo, had a reputation for reading. That reputation is a currency. The night before the hearing, I sat on my floor and listened to the voice memos file again. The air conditioner hummed. Traffic on South First hissed. Dad's voice came through in that friendly rasp he got after long days on roofs. He said, "It is pod tomorrow, so the bank knows no trouble." He laughed. He said, "Linda will have the house. She will be fine." As to what your Karen say, he said, "This is fair." I pressed my palms to the carpet. The word fair is dangerous. It is a story word. I decided not to use it in court. Judges do not distribute fairness. They apply statutes. I needed the clause. I needed the acceptance stamp. I needed the survivorship language. I needed the phrase that would change Linda's face. The morning of August 22nd, 2022, Berger Annex Courtroom, second floor, a pew that smelled like lemon cleaner. Linda sat with her lawyer. She wore a black blazer and pearl earrings. She looked at me without looking at me. We went on the docket as the second matter. Karen stood, crisp and slow. She said we were not contesting the will. We were asking the court to recognize that the Lone Star bank account ending in 6172 was subject to a payable on death designation and therefore not property of the estate. She handed up a packet. Tab 1 was the beneficiary form. Tab 2 was the bank policy. Tab 3 was the statute. Tab 4 was the email chain. Tab 5 was the debit card transactions. She asked the court to order the bank to release the funds to me and to credit the estate for any post-death use of the decedent's card. Linda's lawyer said the will was clear. He said the decedent intended his wife to inherit. He said any beneficiary designation should be disregarded because it contradicted the testator's apparent plan. He said I was attempting to take estate property through a back door. He invoked the no contest clause. He asked for sanctions. He said my YouTube channel created pressure as a form of harassment. He looked at me like I was a headline to be managed. He never once said the word contract. Judge Naranjo asked one question. She asked whether the bank had accepted the designation. Allen, in a suit that fit too wide at the shoulders, answered yes. He confirmed the date of receipt. He confirmed the approval. He confirmed the policy. He confirmed that the bank had held the funds pending direction. The judge read silently for a moment. The courtroom noise dropped. I could hear the security guard shift. Linda crossed her legs and uncrossed them. The judge looked up. She said, "A payable on death designation is a non-probate transfer under Texas law. It is not part of the probate estate. The bank's acceptance controls. The executor has no authority over that account." She turned a page. She said, "Additionally, the power of attorney ceased at death. Any post-death transactions with the decedent's card are improper and must be credited back to the estate or repaid by the executor." Linda's mouth went small. The judge continued. She said, "The court orders Lone Star Bank to release account ending 6172 to the named beneficiary, Ms. Ellison, upon proof of identity. The court further orders Ms. Linda Ellison to file an amended inventory and accounting within 30 days reflecting credit for the post-death charges totaling $6,412.58 plus any associated fees. The motion for sanctions is denied. The no contest clause is inapplicable to non-probate transfers." Linda's lawyer asked to be heard. He said the decedent's intent was to take care of his wife. The judge said the decedent did. He left her the house. He left her the residuary estate. He left her plenty. The judge picked up the bank policy packet and pointed to a paragraph. She read aloud. "The designation shall control over any conflicting testamentary instrument." She set the packet down and looked straight at Linda. She said, "The clause nobody expected is in your own institution's contract." There was no drama in her voice. There was only procedure. But in Linda's face, I saw a storyboard flip. It is the moment people subscribe for. It is not cruel to say that. It is accurate. Real justice looks like a clause, not a crescendo. The hallway after a ruling is where the real conversation happens. Linda's lawyer told Karen we were heartless. Karen said we were organized. He said we were exploiting a loophole. Karen said we were following a contract. Linda whispered, "You won." I said, "I enforced what Dad signed." She said I had no idea what she had carried. She was right. I did not. I just knew what I carried. The weight of being edited out. The bank processed the release on August 25, 2022. The balance, including accrued interest, was $180,207.64. They issued a cashier's check after verifying my identity. I deposited it into a new account with a trust-style title to keep clean records. Karen sent a letter to Linda's counsel offering to treat the Home Depot charges as estate expenses if Linda would stop disparaging me to family. Linda's counsel signed. They needed that win. Small settlements like that matter in keeping the rest quiet. Consequences did not stop at the judge's order. The probate court appointed an auditor 3 months later because Linda filed a late inventory with missing items. The auditor flagged the sale of Dad's F-150, a 2015 model with 92,000 miles, sold to Linda's nephew for $6,500 when the book value on private sale was around $14,000. The court required an adjustment and an additional payment to the estate of $7,500. Linda was irritated. She complained in long emails. She used phrases like witch hunt. The court clerk responded in one-sentence increments, reminding her of deadlines. I kept my answers to filings and nothing else. At Thanksgiving 2022, I did not fly to Ohio to see my grandma because Linda would be there. I sent a letter instead, 3 pages long, with copies of the judge's orders. I told my grandmother I loved her. I said I would visit in January. I did. We had a second formal scene in December at a mediation prompted by the judge to clear personal property disagreements. It was in a law office at 360 and Mopac, glass walls and a bowl of peppermints. A retired judge served as mediator. He told stories about juries. Linda pushed for me to return Dad's old Martin guitar. She said Dad wanted it in the house. The schedule of personal property had not listed it. The guitar belonged to the residuary estate under the will, not to me. The mediator floated a trade. I would keep the guitar, and Linda would keep the shop tools. I agreed. The tools would have meant more cash. The guitar meant more nights with a sound that would outlast the mortgage. Not everything is a ledger. If you are going to fight this hard, you need to keep one object that anchors you. Call that an emotional decision. It is still a decision. In January 2023, the bank sent an amended 1099 INT to my address for the account for that year. Taxes are a consequence. I set aside a percentage and hired a CPA to avoid mistakes. I put $50,000 into a high-yield savings account as a runway for my channel. I upgraded my camera. I hired a part-time researcher at $25 an hour for 10 hours a week. I filmed 3 episodes about non-probate transfers and how to document conversations with aging parents in a way that respects dignity and protects intent. I blurred names. I showed forms. I did not mention Linda's last name. I kept my promise to myself to keep it about the system. That is not kindness. It is strategic. When you tell stories about family and money, you must not turn it into a gossip channel. You must teach a viewer how to survive their own version. In February, Karen called. There was a new filing from Linda's side asking for reimbursement for mortgage and property taxes she had paid during the estate administration and asking the court to consider my actions as an interference that had delayed closing. Karen drafted a response. The mortgage and taxes are normal expenses for a surviving spouse. No reimbursement from me. The estate could reimburse some carrying costs from the residuary if the court approved. None of that touched the non-probate transfer. The hearing took 17 minutes. The court allowed reimbursement for property taxes and denied reimbursement for mortgage principal given the benefit of having clear title to the house. Numbers matter. The order listed $7,942, $19 for taxes. It listed $0 for principal. In March, a detective from the Financial Crimes Unit called me. A bank inquired about the use of the decedent's card after death. The inquiry is routine. The detective asked if I wanted to press charges. I said no. My goal was to restore the money and to have clean accounting. A criminal case would not improve my life. It would not change the house deed. It would not make my father come back. Declining that path is not forgiveness. It is strategy. By June 2023, the estate closed. The court signed an order discharging Linda as executor, subject to any later discovered assets. There was no celebration. There was a page in a file and a sigh that felt like a sliver leaving a finger. I went to Whataburger and ordered the same number 1 I had eaten with Dad. I sat in the truck of a friend because mine was in the shop and listened to the audio one last time. Then I archived it in a folder labeled Dad. I did not delete it. I just decided I did not need to listen again. The part that viewers always ask for is the human cost. What happened to Linda and me? We do not speak. She sent one email in September saying she hoped I was grateful. I responded with a one-line thank you for paying the property taxes on time and a copy of the final accounting showing the credit back for the debit card use. No sarcasm, just paper. My grandmother and I have rebuilt a path that avoids gossip. My mother sends me articles about estate planning with sticky notes that say, "Now we know." My channel grew because this story resonated. I did not plan that. I would trade the views for an hour with my father drinking coffee on a porch. Since I cannot trade, I am careful with the views. I tell people to write, to record with consent, to get beneficiary forms confirmed in writing, to talk early and to talk with the words that courts understand. If you are watching because someone told you that a will is everything, hear this. A will is a script for probate. A beneficiary designation is a contract with a bank or brokerage. The two talk to each other only when the law tells them to. The law in my case said the designation controlled. The bank's policy said the same. The no contest clause did not reach outside the will. The power of attorney died the moment my father did. Those sentences sound dry. They are the hinge between losing your voice and reclaiming it. I have thought about the scene where the judge pointed to the paragraph and read it out loud. The clause nobody expected was not a trick. It was a paragraph anyone could have read 6 months earlier. Why did it still feel like a twist? Because people tell themselves stories about fairness and then stop at the border of contract. Linda believed she had order. She believed a will is a shield against every other piece of paper. She believed she could decide who was family by framing 4 pictures on a mantle. The bank believed what its policy said. The court believed what the statute said. My father believed me when I asked to hit record. Those beliefs collided in a room on a Monday in August. The result was not cinematic. It was better. It was final. The consequences for me are measurable. I have 180,207, 64 less taxes and fees, which became 165,111 after I did everything right. I paid Karen 7,560. I paid my CPA $950. I donated $1,000 to St. David's in Dad's name because I wanted something peaceful in the ledger. I set aside $30,000 as an emergency fund. I invested in my channel and in a research subscription that lets me pull public records faster. I started a series on how to document elder care without becoming the villain. I answer the email that hurts the most once a week and then close my laptop. That email always says, "I did not record, and now they say I am lying." I tell them what you now know. Write it down now. Collect the bank policy now. If you are the adult child, ask gently about beneficiary forms now. Ask to be added, not to everything, but to one account that can carry you if a storm hits. Ask to hear the story your parent believes about fairness. Then ask where the clause is that makes that story real. For Linda, the consequences are clearer in property records than in her voice. She recorded a warranty deed in April 2023, confirming her title to the house. Good for her. She listed the house in June 2024 for $597,000 and took it off the market in August after a price cut to $569,900. I know because my channel's researchers flagged it in the MLS. She is not remarried. She posted fewer photos. She may still think I stole something from her. She is wrong. I enforced one contract and pushed an executor to account for uses of a card after death. If you think that sounds clinical, you are right. Grief taught me to count before I cry. There is a long tail with family. Someday I will be at a wedding where Linda stands on the other side of a circle of chairs. We will both clap for someone we love. We will not speak. That is okay. Justice does not require reconciliation. It requires a record. Mine includes a recording in a truck at a Whataburger, a bank form with a barcode, a judge reading a paragraph aloud, and a cashier's check that turned into a deposit that turned into a runway for a voice that will not be cut out of the slideshow again. If you are here because your thumbnail promised revenge, consider an upgrade. Ask for clarity. Ask for the paragraph. Ask for the clause. Ask for the count. Ask for a judge who reads, That is the kind of justice I can promise to narrate. 96% of viewers are not subscribed. Please subscribe, like, and comment.